आज आप सारे आए हैं कश्मीर
मामा मामा आई नहीं
आप कौन पहनते हैं मैं कौन पहनते आप खाना शादी वाली तो ये मैं कौन पहनते नहीं किसी अजीब नहीं हाँ तो क्या नाम तो नहीं बता
अरे बाबा सोई हो रही है
मैंने को वाइट फॉरेस्ट का मेंबर बनाया है जंगल नहीं भाई साहब वो तो क्लब है अरे बाबा जब यहाँ आएंगे
Must have just now. Assalamualaikum sir.
अस्सलाम वालेकुम सर।
Walaikum salam. How are you?
बस सर आपकी दुआ होनी चाहिए। आई एम फाइन। सर आप कैसे हो सर?
I am fine, sir. I'm very fine. How are you?
सर आज तकरीबन 2 साल के बाद आपका चेहरा सामने आया सर।
I'm here every time for you.
सर थैंक्स सर, थैंक्स सर।
Sir, Assalamu alaikum to everyone. I think, sir, it is already 8. So,
Yeah,
and we have a good number of people as well. So, I think we will start.
yes.
So, good evening, everyone. It is our great pleasure that today we have a very important guest with us in the context that this group is especially made for young lawyers who want to be guided with material as well as experience of senior lawyers. And who better than Mr. Mushtaq Ahmad Dar, who is a celebrity lawyer in his own standing, and very few lawyers attain such courtroom stardom as he has, with a deep baritone which sets him apart from the rest of the lawyers without any doubt. And whenever a new junior comes to the court, he cannot but he cannot but behold this lawyer talking in a very deep voice and mastering the courtroom at the same time. Now, why this lecture is important is also because the topic of the lecture is probably the most difficult skill that a lawyer needs to inculcate when he's practicing or carrying out trials, which is the art of cross examination. And Mr. Mushtaq Ahmad Dar, being a top lawyer himself, especially on the criminal side, there is hardly any other lawyer of his stature. And keeping into the fact the importance of cross examination in both criminal as well as civil litigation, it today's lecture becomes all the more important. So, without further ado, I take this gracious opportunity with both hands and at the same time, hands folded, a request to the Honorable Senior Counsel to start today's lecture.
Good evening, everybody. I am, yeah, said much about the part. I'm not saying the art of cross examination is a natural art. It cannot be inculcated or it cannot be taught. It's very natural. But we have to see as to how the cross examination has to be conducted, especially in a criminal case. The most important fact is what a lawyer and should know about concerning a witness. Uh, the first thing is the lawyer must divorce, divorce and deviate because he should be focusing on his subject and should not at least divert his attention towards something else. He, the lawyer must first and foremost know the language and the body language of the witness. The witness is of great importance in the cross examination because he is in cross exam, and it is the witness who is to be cross examined. But how he is to be cross examined? To be a which would be called the best cross examination. We we must know the witness who is the witness. We must know about the witness completely, his character, everything, so that we may not be short of the questions for him. Even we can say that the character of a witness, but that could only be possible if we know about him. We must gain the knowledge about the witness. Then the second important thing is the we have to see who is the witness. Is he a witness who is a natural witness to a particular offense, or whether he is planted or a projected witness? The most important thing is one more, that is whether witness is interest witness. We find interested witnesses in the witness box when we are considering the witnesses. The we have how we have to confront the
Sir,
witness
I'm
with
sorry to interrupt, sir.
Yeah,
I'm sorry to interrupt, sir. The voice is breaking from your side.
it's very
So yeah. So if you can please disconnect and connect to the call once again, I think the matter would be resolved.
okay. इसमें ये right voice break होती है. Yeah. So I'm saying that we can
We'll wait for a minute, sir. So if you can reconnect to the call, it will probably help the connection.
so we must confront the witness with the situation that surrounding. How could we know the situation surrounding of a particular place where the alleged occurrence has taken place? It could be only possible when we personally visit that place and visualize the things ourselves, get a first-hand knowledge about the situation and surrounding. Then the second, the one more thing is we have to control this witness. If he is to be subjected to trust, we have to control the witness. How we could control the witness? We have to track and take the witness to demolish the lies and get truth on surface. Because in the modern system of judiciary, we see the witnesses are planted and evidence is budget and padded. How could we be able to demolish and destroy the padded and budget evidence? We could be only possible if we know about the case fully well as to what is our case, what are the facts, and what is the law on the subject. If we don't know about these things, we'll be not doing justice to our client or to the society. Then one more important thing is that the witness on occasions requires to be, we have to first very friendly with the witness. First, on occasion, we have to annoy or open the witness to get the real, actual, and correct answer to bring the truth on surface. And we have to expose the lies of a witness, how it could be possible. Because many of the witnesses are being projected as eyewitnesses who are not really and actually the witness of occurrence. They are being planted. So those witnesses have to be taken care of. Those witnesses have to be taken. We talk the voice problem.
The voice is continuously breaking. I did not want to break your momentum, but we have to check the connection again. Good program is going to end in wasteful like this. Oh, we believe it will not. Let's try to make the most of it.
Please ask sir to remove his earphone.
Okay, sir. So this is a good suggestion, sir. If you can try speaking.
It will improve voice
Yes.
quality.
Yes. Otherwise, the video is coming clear.
Video
So
is
I
coming
think.
clear, but voice is not coming clear. I
Yeah,
think
yeah.
if he removes earphone, then voice will become
Yeah.
more clear.
Yes, sir. This seems to be a good suggestion, sir. Probably the problem is with the earphone.
बिल्कुल बिल्कुल sir. Okay.
So we have to, first of all, be in know of our case positively. We should not show any delay in getting and knowing the case and then cross-examine the witness. When we know the whole case including the statements of all the witnesses, documents, and the reports, other annexures. So it could be only possible if we know the case and the law on the subject. Thereafter, we can go for a very good cross examination. We We must remember this statements of the witness, prosecuted witness, or whosoever will be able. We must know what he has stated earlier during in the course of the investigation. When we will master over that subject, then we can confront him with the details, with the cross examination, and bring him down, pull him down, and bring the laurels for our clients. Then one more important fact is if the lawyer who is conducting the cross examination, he must know every law, the law about the origin and evolution of cross examination. Then this cross examination is not confined only in the evidence act, or not only it has its origin and evolution also in code of criminal procedure in section trial under section 227 subsection 274 read means section 2 in which last line is further cross examination. In that event we can go for further cross examination of a witness who has already been examined. So this is the law on the subject. So now we'll take up a case that a witness who is a witness produced by the prosecution, how we would examine him and how to start examining him. We have to know about his qualifications, uh, know how about the case, and then put him the questions regarding our subject. We have the statements, his erstwhile statements. Those statements have to be put to him, and he is to be confronted with the statements of the other witness also, which could only be possible when we know the case fully well. Here again, the witness has to be got to know that he is being subjected to cross examination, and the lawyers who are skilled lawyers, they command the witness, they take him to the uh, case and facts which are adverse to his case, because he is supposed to know the truthful facts. It is not always a witness would always be uh, demolished, but if a truthful witness is there, it is very difficult to demolish such a witness. But if the witness is a trusted witness, granted witness, and a resort has been made to finding out evidence by the prosecution, by the investigating officer. In that case, we have to put our all efforts, and we have to do to the best of interest of the client in the law to get the real truthful fact before the court so that justice is done to the parties. Again, we have new laws coming to be day by day. We have the electronic evidence nowadays. Very rarely the lawyers are resorting to the electronic evidence. This electronic evidence has become the part and parcel of our daily life because we find CCTV camera installed, we find these CCTV cameras on road, in police stations, in jail, in homes, everywhere in offices. So this evidence has become very important, and we require ourselves to get the best out of this electronic evidence, which is virtually truthful evidence recorded in due course of law by gadgets which are available like CCTV cameras and the other equipment with it. So recently we have been conducted cases under the Information Technology Act cases and that too under the Evidence Act. We have got a special provision in Section 45A of the Evidence Act and also Section 51A, 51 of the Evidence Act. An examiner of electronic evidence is being and he is being appointed, and his appointment comes from the central government. She is qualified as an examiner of electronics. But I have found as a criminal lawyer myself, in very rare of the rare cases, his services are resorted to, his services are not got, or he is not being engaged to get the electronic evidence proved in due course of law. This examiner of electronic evidence is a very important way nowadays. But in most of the recent cases, I don't even find a word or whisper about this examiner of electronics. Now the question is, who is this examiner of electronics? He is being appointed, and his services are to be got for finding the truth by utilizing the most important evidence, that's called the electronic evidence. This electronic evidence is very essential nowadays. Now the people are arrested. The people are arrested unlawfully and illegally and lodged in jails. In earlier days, it was the practice. Nowadays, in view of the law laid out by the Honorable Supreme Court in 2020 December, that the all the central government agencies and the state government agencies, including police stations all over the country, have been asked to install the CCTV camera in police stations, jails, and in central agencies, especially in the most important, where the investigation is being conducted, where a person is subjected to thorough interrogation by the investigating agencies. So the question of getting a person and not showing his arrest gone are those days by the law laid out by the Honorable Supreme Court, that the governments and other agencies have been made to uh, get these CCTV cameras installed. So if a person is arrested, he is taken to police station, but his arrest is not shown, we can get these things clear by resorting to these electronic evidence, apply to the court, and even ask the witness as to when you were got in the police station, what was the time, the electronic evidence would be this, even the seconds are being counted in such situations. So the this evidence is not being evidence. This method and mode of electronic evidence is still very fragile. It is not utilized. Reason being, the people do not, even the investigating agencies, which are very high, high profile and very renowned, I find there that they are they are not even using such electronic evidence. Therefore, my endeavor would be to advise, to rather to ask the youngsters to go to this subject, this information and technology and the evidence, and pay a heed to it, learn about it, so that you could be best cross examiners about the electronic evidence and how to get this electronic evidence on record. In a very recent case of mine, a person was arrested and his arrest was not shown. I moved a petition before a learned special judge, session judge, for getting the report from the this electronic evidence from the concerned police station. This was dodged for some time, but finally the police station SHO concerned was directed that it be produced. Finally, they produced it, but unfortunately, they then uh, uh, did the good things. They raised the huge because she was falsely implicated in the case. So if we see that an accused is detained in the police station or a witness is coming to the police station and his statement is recorded, then it gets recorded. Uh, even the actual time, seconds, or give minutes or being so we can confront after getting evidence. This electronic evidence has become so important because earlier there were there used to be the custodial killings. There used to be offenses committed by khaki people in police station. That has taken drastically because of the law laid down by the Honorable Supreme Court. And the Supreme Court still in 2023 was after the state agencies and chief secretaries, police DGs to uh, take it very seriously and implement these laws. The Honorable Supreme Court finally constituted a committee, directed the central government to constitute a committee. That committee is called Central Oversight Board, which is monitoring all the police stations, all of the jails, as well as all the agencies. Then subordinate to that, there is another agency called the State Level Oversight Committee. They are they are managing these affairs of electronic evidence and CCTVs in head office wherever it is located. Finally, we come to the district level committees, which are in every district. Such committees also monitor and get the electronic evidence preserved. This electronic evidence, when is available or made available in due course of law, it becomes very easy to cross-examine the way, very easy to cross-examine the witness and get the real fact, get his innocence and false implication established in due course of law. Here again, we have the law that the police rules are there, which are made under Peace Act. I have not usually found anybody resorting to these police rules. We have a rule 517 of police rules. That's the rule pertaining to the entry of a person in the police station or his exit, whatever, whether he may be a civilian, a common man, or a police personnel, his entry and exit as well as purpose of visit is recorded. Therefore, it becomes nowadays very easier to get these registers. That register is called the daily diary. Uh, in Urdu, it's called Roznamcha. When it is not recorded, the entrance or exit of any witness is or accused is not recorded, then it becomes doubtful. Finally, they could be dealt in accordance with law, and the accused could get benefited by such rules, by such a record, if it is not found in record. Uh, I have obtained an order, very good judge, honorable judge from Badgam. I moved a petition, such and such pictures, these registers, BOA registers mentioned in Rule 4, 514 of the police rule, and that application was granted. The police was really worried about the case because by that application, truth has definitely come out, and it was found that the investigation conducted was before the law and rule, and the investigation was so badly conducted, and it is going to help the accused when the investigation is not conducted. And the statements of the witness have been recorded, say particularly on a particular day. But in the fact of the matter is that no such evidence has been recorded in the police station on such day. And it would be again very easier for us if a Caesar memo is prepared. It is to be sent definitely after Caesar memo is prepared and something is seized. It is to be put before a magistrate who has to take the cognizance of the case. And along with earlier there was law, the statement under section 161 of CRPC was to be produced before the magistrate immediately after it is recorded the way the statement under 164A earlier was recorded. So there have been now very good checks made that the police has been told that they should not enter and do things which are totally unlawful and illegal being done by the police agencies and earlier. These acts have saved many people. Reason being that the Honorable Supreme Court takes such things very seriously and lays down the law. Even the installation of CCTV cameras in police stations and many other prominent places, the Supreme Court is, Honorable Supreme Court is still with iron fist after the states and the central agencies that it must and should be implemented and adhered to strictly. So when we have all these measures taken, coherent and corrective measures taken, then justice is done to the bodies. Innocent people are not being involved in false cases. And these records help to the great extent that we get justice for the parties to the privy. In recent cases, if a material is or a weapon is obtained and if it is not entered in the concerned register, we have a register uh, usually called the store register, Alkhana register. If it is not entered in that, the whole process becomes doubtful because it is mandatory. Because it is mandatory because that police has to perform their duties in accordance to rules, regulations, or law. They are not superhuman beings. They cannot go towards the law. When it is proved and proved that the police has acted against the rules and regulations, they have violated the law. In that event, we could easily go for a good cross examination and get it shown and proved that this is the wrong committed by the police agency. In many cases, I have seen, I have a very long practice in doing criminal cases. The question of arrest in a particular case is shown uh, after today he is arrested, the arrest is shown after 10 days. The person is illegally kept in wrongful confinement. In one of the recent cases, the person was arrested and lodged in the police lockup illegally, along with three more projected witnesses. They came and deposed that we were arrested on day 4. Thereafter, arrest has been shown or their statements have been recorded after 10 days. Therefore, it gives the confidence to lawyer when he knows what he has to do, what is the law about it. Because I am finding every time that police rules are neither being adhered to or implemented by the investigating agencies. Even the who is the charge SHO of a police station. There's a rule for that. If the actual goes out on some duty outside the police station or beyond the jurisdiction of the police station, then the charge is given to some other officer, subordinate to him, or even the charge is given to the Mohrir to this police station clerk. So these things are very important because the best and important tool for cross-examination. If during the course of the cross-examination we ask such questions to the witnesses especially in our this legal Goho, Goha, we know for sure and certain that Arya he has been and is the first judge of criminal case. Then we must confront him with the law, rules, regulations, facts, and the documents about the case. I have very recently in a very murder case asked an IO what was the necessity of physical padding test when you say a person is an examiner of electronic evidence you have mentioned, but is the person qualified, duly appointed by the government of India? The learned that SHO, DYS, he will be there to satisfy the legal procedure for the fire. In this situation, we have to do only one thing. We must interfere with the CRPC Evidence Act and other acts, the Evidence Act. There are now many more cases. We'll now shift to POXO. In POXO cases, these are now very common cases and are heinous and serious in nature. So in these cases, also we have to be very careful. Even the people, the parents of the daughters, they resort to false and false uh, making of cases against the innocent people by fighting at bad. The Honorable Supreme Court has time and again warned the court that they should check such things because innocent people are now being falsely implicated by padding and fight. When this is knowledge of the Supreme Court in about these cases that false implications are not uncommon in our country. Thereafter, they warned the judiciary as well as everybody that they should not resort to fighting and fighting up. This fighting and fighting up evidence is so common, especially in these cases also of POXO. The get bail in POXO, it is very difficult, but we have to see the medical opinion, the age, and other things which are material for ascertaining what are the real facts and how whether the person has committed or not. The then we have the cases of unlawful activities. The unlawful activities is a very harsh and very serious law dealing with the terrorists and other people who are resorting to violence, creating havoc by terrorism. And this law was created, but this law too is being misused and used by the agencies. So we have all to do that. We must know the law first, then go for the cross examination. The law and rules are essential for a very good cross examination. This could be done only when the case studying is exhaustive, complete, so that the person, whosoever is the witness box, he could be confronted legally and lawfully, and the accused could be uh, given the justice. Now, one more important fact is that the laws regarding anti-corruption, prevention of corruption, and there are other laws, the law of narcotic drugs and psychotropic substances. How people are being involved in narcotic drugs and psychotropic substances act because the money is being demanded, otherwise innocent people are being falsely implicated. So these things could be done away with only by when good lawyers and very good lawyers they resort to knowing the law, how the evidence is being fired. This is going to do justice to the party. Now coming to the case, I'll give an instance of a case. The Honorable Supreme Court in a judgment in 2014, a girl of 4 years war in Gujarat. He was taken by some person and evidence was uh, recorded. The session court convicted the accused about death sentence. Then matter were tried. It was finally matter went to the Honorable Supreme Court. In in that judgment, the Honorable Supreme Court has expressed anger and anguish over the working of the agencies, judicial officers, and the court says, the Honorable Supreme Court says, we could not deliver justice to the girl who has been raped and murdered, who has been just 4 or 5 years girl. And they have shown that these things have to be conquered instead of giving justice, the fair and impartial investigating the case. You are getting the innocent people and getting them convicted or uh, make them to suffer incarceration for a long period. These things really require to be tackled. Because the Honorable Supreme Court is the highest court of our country. Now, the judgments of our Honorable Supreme Court are being adhered to, adopted, and cited all over the world because our judiciary has such a ties in doing the justice. I'll remind you of a case of the Honorable Supreme Court in which a Pakistani terrorist was avoided death sentence because of a blast done by him at Pune. He was convicted about it. Thereafter, again the same person, he filed an appeal. He was awarded this death sentence, and his death sentence was confirmed by the High Court of Mumbai. Finally, met on the Supreme Court. Madam. Is here what happened in Honorable Supreme Court? Said that the person has not been given the justice. She has not been represented by a very experienced, not a good lawyer. She has been represented casually by somebody. This is the beauty of our judiciary. This is the beauty of our judiciary that the people get justice, whosoever he may be. Maybe a terrorist of Pakistan in that judgment. The Honorable Supreme Court then gi- uh, reduced that death sentence to life imprisonment, and after he was reheard and retrial was conducted in the case, which shows the fact that the judiciary is very smart, very alive to these facts that they want justice must and should be done to the parties. Here in J&K, in one of my one case, he was being conducted by a very lawyer of the J&K, but the learned session judge gave him the conviction of life. I I filed an appeal in that case. The in the appeal, what happened that the Honorable High Court was of the opinion that she has been falsely implicated, but the orders have not yet come. But the matter has been partly heard because of the fact that the High Court, these constitutional courts, they very seriously apply their minds, thoughts, and soul to the facts and law of the case, and they do the justice. So we should also, when we are lawyers, we must do the things that read the law, know the case, and then go for cross examination. This cross examination is the best tool given to a lawyer to get the truth crystallized. If this is not done, because of lack of knowledge in that event, we are not given and contributing the judiciary. Even we are demolishing the very basic fundamentals of the justice. In this backdrop, I would say that the lawyers or budding lawyers or who have to try it, they must not waste time because they must take the profession so seriously and work very hard every time, give more time to their cases. And in case of they have the leisure, they must and should go to the courtrooms where the witnesses are being examined, cross-examined, whatever may be, and even they must and should go and hear the arguments of the lawyer. We have got very good lawyers in the Honorable High Court, in Sessions Court, so that let, let them learn, because in the courtroom is the best teacher for everybody. It is for a lawyer, it's for a prosecutor, it's for a judge. This is the most learning this temple in the judiciary. Every courtroom must be taken very seriously, and every judge must encourage such lawyers, youngsters, boost them, teach them, make them to learn, so that we can get very better and bright future lawyers and judiciary. If we get very better and bright lawyers, those are going to give us the justice to the parties, not to accuse, not to uh, only accuse, but it must be given to the complainant side, the victims. We have nowadays the victims also. The justice is to be done to the victims as well. So in this situation, what is the most required thing is that the lawyer must first of all do to try to learn his case, know his case so seriously and nicely. Then he can go for a very good prosecution and go for doing justice to the court, to the his party, to the other side.
Sir, if
Otherwise,
if
if
I
he
may
is
come in for a second, my apologies, sir. If I may come in, you have laid and rightly so, sir. You have laid a broad picture of practice in criminal
yes,
law,
yes,
especially focusing on the art of cross examination, which
yes,
is today. But I think, sir, my humble submission would be that since this is a matter of practice, what the this cross examination is a matter of practice, and I think we have other lawyers here, junior lawyers here, who want to learn from you from specific instances of their cases when they have cross-examined, the difficulties they have faced in cross-examination, because obviously it's a very context-based thing, the art of
yes,
cross-examination.
yes,
So I will request other participants to also please come in and ask sir questions based upon your experience or any question of law which is in your mind, finding answers. And I'm sure sir would be more than glad to take up
yes, ma'am.
questions so that we
Ready
can
to.
give a context to today's lecture as well.
Thank you.
So anyone who wants to ask questions would simply have to raise their hands. Then we'll call them one by one and we'll ask questions. Mr. Roof Pare has raised his hand. Mr. Roof, please unmute yourself and ask your question.
Yes, Mr. Ru.
Sir, I think he has forgotten after raising his hand. So yes, now we have another hand which is raised. Activities people. Mr. Shahryar, please unmute your mic and ask your question.
अस्सलाम वालेकुम सर।
Walaikum salam.
सर मेरा क्वेश्चन है कि जो एक अक्यूज्ड है वो भी
हम्म,
एक कॉम्पिटेंट विटनेस हो सकता है,
हम्म.
लेकिन हमें उसको कब एज विटनेस प्रेजेंट करना चाहिए और किन चीजों का ख्याल रखना चाहिए?
It is provided in the Code of Criminal Procedure. When the evidence for the prosecution is proved, thereafter the defense is asked to produce evidence if need arises. When need arises, that the accused could also be one of the best witnesses because he is eyewitness to such things, and he could be examined as a witness. There is no bar, absolutely no bar. He could apply to the court that I want myself to depose as a witness in the case against me.
सर लेकिन किन चीजों का ख्याल रखे, तब कब उसको रखे, बिकॉज इट्स अ डबल एजेड स्वॉर्ड.
He is to be examined. It is his choice. If he is asked to lead in defense, he could be the first person to get himself examined. There is no bar, there is no limitation provided that he could be examined only after all his witnesses are examined and there are defense witnesses are examined. Thereafter, he will be examined. It's not, there's no bar.
Okay, sir. Mm, till the time that someone else raises his hand as well, I have a very small query, sir.
Yeah.
So we'll take the question beforehand because I don't want anyone to miss their questions. Mr. Advocate Fayaz, please ask your question, sir.
Sir, good evening, sir. It's an honor and pleasure for us, all of us, that your good self has been delivering a lecture today. It was a very wonderful lecture. What I would like to gather from your good self, because of the experience your good self is having in the practice of this criminal side, in bail matters, especially what I have seen, the lawyers are always very panic to get their bail application decided. At some point of time, what I have observed, that judge feel at times the pain and pressure that they are inclined to dismiss the bail application, though at times there is a merit in the bail application. But the judges are not inclined to exercise the discretion which they are supposed to exercise in favor of the accused person, keeping the nitty-gritties into consideration, social impacts, other things into consideration. What must be the endeavor of a lawyer to come out of these wriggles? Should he wait? He should read the mind of a judge? How he should come to the conclusion that at this juncture I must press it, so that the judge will not get annoyed, or so that he will be able to get the bail. No doubt there are petty matters, for example 379, but there are some matters, for example anti-corruption bills, other bills, where where the patience of a lawyer is also taxed by the judge. What must be the beautiful endeavor of a lawyer? Because the young lawyers who are otherwise, sir, who are watching the lecture, who are observing the things keenly, what must be the advice from your good self to all those lawyers?
It's a very good question I have got from you. I appreciate for this question. This is the problem of every lawyer, I should say, because the Honorable Supreme Court has expressed pain over the conduct of the judiciary and the judges for not deciding the bail applications within short spell of time. This uh, Mr. Ramana was the Chief Justice of India in the yesteryear. He had also, in his one of the judgments, said that the lawyers are not heard in case of bail applications because the delay is being caused in disposing of the bail applications. Earlier, there was a judgment of the Honorable Supreme Court that bail application must and should be decided within 7 days. Then recently laws have come, no, it has to be decided within a period of 15 days and 21 months. But this is not the practice. The judges time and again say that we have other cases, we cannot devote every time for these deciding these bail. But the Honorable Supreme Court, if would take these things very seriously, lawyers are suffering. If you are asking a judge to decide this bail application immediately and urgently, he would say, I'll reject it. This is not that the judge has indefinite and unfettered powers. He would dismiss the bail application. That's why we have the regional courts, appellate courts, writ courts. We can go under 227 to the High Court for setting the orders right. But the judges, there are very good judges also who pronounce the judgments in the bail applications as early as possible because the Honorable Supreme Court has said that the rights of an accused are guaranteed under Article 21 of the Constitution of India. So, why should they delay the bail applications, or why should not they, as early as possible, decide to bail application so that the person could be able to avail some more opportunity So this is a very important question raised. It's a problem of every lawyer.
Sir,
What
basically,
the Honorable Supreme Court has.
basically, sir, I got your answer. Basically,
Right.
what I'm trying to ascertain from your good self is that, as a matter of fact, the legal implications are always there, judgments are always there, deciding of a bail application by a particular judge within a time frame. That is already settled in terms of the law laid down by the Honorable Supreme Court, High Court, so on and so forth. That's not an issue. But at times, sir, what is important, more important, because the young lawyers, I have seen the lawyers who are getting the bail applications. Because once a person joins in this profession, he gets a bail application. He's of the opinion that he will earn out of this.
Yes.
But at the same time, he feels he has to exert the pressure. He has to exert the pressure by his client that he must get the bail. That is one part of that's legal implications. One part of it. How to motivate a judge? Sir, I am getting the judgments now in light of this judgment, that judgment on the law is settled that I cannot be denied this bail, that bail. Bail is always, if we will go by the conduct, if we'll go by the law, bail is always the discretionary power that's to be exercised by a judicial magistrate or by any other judge, whosoever is conferred with that power. My submission before your good self is that what kind of patience, what kind of endeavor a lawyer must exert upon the judge, because if he gets the bail application dismissed, sir, for example, he has a remedy available in terms of the law, but at the same time that will get his cause delayed, that will get the cause delayed for a while. He will have to file a fresh bail application or a revision application before the higher forum. That may take time. But if there is any sort of technique, because one has to read the mind of a judge, so that reading of the mind of a judge always comes with the experience, because experience gives you the wisdom. What must be a young lawyer do? What must the young lawyer do in order to ensure that the judge before whom the bail application is pending, that he's not getting irritated. He also feels that this lawyer is feeling a tremendous pressure from the other side, so that he may exercise the discretion in favor of that accused person and this young lawyer. He may also be able to fetch something out of it, and at the same time accused will also get released from the custody. That twin objects will be resolved. The young lawyer, he will also get boosted, he will also get encouraged. What kind of technique he must adopt apart from that legal implication, judgments, whatever, let us leave that part aside, sir.
Very
That's
good
my
question.
submission.
But the question is, these problems, rather these problems, I am even now facing. The bail applications are not being taken very seriously by the learned presiding officer. They don't exercise for or against a person because they delay it. Otherwise, there may be a bail application which could be decided within half a day or within a half an hour. But the judges enjoy giving the dates. If the judges would be very serious about deciding the bail application, this person would have not been there. They say that we'll get objections, then objections are heard, and I can delay it. We'll see case diary. They know about the case. It is the judges who ought to be made to work and pass orders. It is the Honorable Supreme Court. Even I have seen a recent judgment in Honorable Supreme Court has shown its ability and anger, showing that the trial court judges they don't grant the bail. Reason being, the Honorable Supreme Court has also taken cognizance of these facts that it is not young lawyers. Every lawyer is being bothered. Bail applications are not decided. If pressure a judge, pressure a judge to decide here my application expectancy today, tomorrow, he will say I reject it. Then you have to go to higher court. But by the time you'll be growing up and you'll learn how to learn the patience and work patiently. This law, there must and should be a law made down by the Honorable Court or law got incorporated that bail applications must be decided within day, 2 days, 3 days, maximum week time. Why should these bail applications be kept? The liberty of a person is of prime importance because if somebody's liberty is curtailed, tomorrow one fine morning, it is found that he has been unlawfully and illegally involved in the case, then where he would go, he would suffer incarceration and he is being detached from the He is being looked down by the society. These things have to be considered by the learned judges. That bail application, especially of the youngsters, required to be decided within days, 2 days, weeks time is a much time according to my opinion in deciding the bail application.
Okay, sir. Thank you. Sir, one more now. I would like to submit one more thing apart from questions because your good self is a legend in this criminal side. We have been witnessing such a wonderful lawyer. I am a great fan of your good self. At the same time, sir, I would like to request your good self because the youngsters who are watching you on the courtcast, what will be your advice, sincere advice to them in order to become the good criminal lawyers now? Because day in and day out, we are feeling that our system is lacking in terms of this criminal law because we are not getting ample criminal lawyers as on date, sir, what we should have, because we have a great potential in this criminal side, sir. Therefore, these youngsters, what must be your sincere advice to them, how they should penetrate into this side, and what must be the challenging effect, what must be the challenging time for them so that they will come up through all these things in order to become the good, they will be shaped up as very good criminal lawyers, sir. That I'll be that requesting your good
For
self to give them a good advice to that.
for a good lawyer, younger or older, there is absolutely no testing time. If a young lawyer gets a case, very serious and heinous case, she has to prepare it, fight it like a warrior and get it to the conclusion in his favor. Reason I have my own this young stage, in my own young stage, I was just a fresher. I got a murder case. And in the murder case, two accused had given statements under 164 before a magistrate. They have rather confessed the crime. And I had very good luck at that time. I got a judge who was one of the best judges as second additional session judges. His name was Mr. Gupta. He got elevated as judge of the High Court. You know what he did? He heard my arguments and discharged my two accused in murder case. Despite the fact the statement was given by them that they have committed the murder before a magistrate. These were the judges. Now we have this time also very good judges, but it is up to the judge. He must and should appreciate the law, facts, and pass orders, least caring for the outcome of the judgment. He has to deliver this law judgment in accordance with the facts and circumstances of the case, and he'll be deftly appreciated by everybody for laying down or passing good orders and judgments.
Thank
Thank
you,
you,
sir.
sir.
Thank you, sir. So nice of you, sir. Thank you, sir, for giving such a wonderful time, sir. Now, courtcast moderator, this host is there, sir. He may take every care of. I am thankful to your good self for giving such a wonderful suggestion to those youngsters. Thank you once again, sir. Thanks a lot.
Sorry.
At the end, sir, thanks a lot for today's session. And it was a well rounded session in which we covered almost all the major aspects of a criminal trial. And you were also very gracious to explain in detail the differences between trials of different nature and under different special statutes as well. So I'm sure it's enough food for thought today, and it gives us enough material as well as inspiration to focus very seriously on criminal trials and, of course, to do better. And we leave you, sir, with the hope that they would soon, inspired by you, there would soon be a battery of young, brilliant criminal lawyers with us.
I
So,
wish
with
them
that,
success. I wish them the success. I would only request them to work hard,
yes, sir,
least caring for the future. If they work hard work is the key to success, and they'll be successful
definitely,
definitely.
sir. And they will always need your guidance, of course, sir. I'm sure
I'm
we'll call
always there.
some other
I'm always
panel.
there. It will be my greatest pleasure to have them if they require my services anytime, anywhere.
Thank you, sir. Thank you, sir. I am also witness to that. You are available to us juniors very openly and very graciously, sir. Thank you. Thanks a lot
Thank
for
you.
today's lecture, sir. And I'll also thank other participants who are present as well as who have already left us for making today's session a reality. Thank you.
Mama,